I would like to acknowledge you with appreciation for accessing this video presentation and you taking time to watch and listen to it. My name is Brighton Cavallo, and I do serve as the Public Affairs and Religious Liberty Coordinator of the South England Conference for the Seventh-day Adventist Church Organization in the UK. I will now share with you the screen for this presentation. And once again, I'm grateful that you are able to join me. The title for this presentation is on the first slide before you, and it reads, Freedom of Conscience and Legalizing Assisted Dying / Suicide, Legal Ramifications. In this private member's bill now in the House of Lords. The main purpose for this presentation is intended to share with you a legislative and legal perspective of the Terminally Ill Adults End of Life Bill, following, that is, in the House of Commons at its third reading for England and Wales, and thereafter sending it to you in the House of Lords. Whilst my presentation, I'm mindful, is earmarked for the House of Lords, that is the peers, I'm also making it available to the public for it to be aware. You can see the House of Lords and its peers. Now, leading to the House of Lords being invited to attend to this bill, I just want us to reminisce how it all started. The Terminally Ill Adults End of Life Bill, the slide before you, was introduced on the 16th of October 2024 as a private member's bill for England and Wales only. And this was introduced by Kim Leadbitter, a Labour MP for Spen Valley. After which, this bill had its second reading with a debate and votes taken in the House of Commons on the 29th of November. It passed with 330 in favor to 275 against, a majority of 55. And most recently, this Terminally Ill Adults End of Life Bill had its third reading, here again with a debate, and votes were taken on the 20th of June 2025. It was backed, here again, by 314 votes to 291, a majority of 23. Thereafter, having gone through that process with committee stages and amendments being obviously looked into, it is now in the House of Lords. The slide before you shows its passage. The House of Lords will go through it, make their amendments before being forwarded back to the House of Commons for the final stages, and if passed, sent to Buckingham Palace for the royal assent. I just wanted to provide that passage. Now, the private members' bill in the House of Lords uh, will, in my view, equally be very important. I just want to provide a brief background to the legal and legislative issues I consider as important to remind myself, to remind you. Now, Homicide Act 1957 for England and Wales clearly showed one could not and was not allowed to commit suicide or to be assisted to commit suicide. That's very important to acknowledge. Homicide Act 1957. But then some changes did come. But prior to that, it was interesting that life was seen as sanctified, a human sanctity. And this was duly acknowledged in English common law. S.M. Cannick in 1997, writing in the constitutional aspects of physician-assisted suicide after Lee versus Oregon, in that journal, quote unquote, the English common law, according to him, it perceived suicide or taking one's life as an immoral, criminal offense against God and also against the crown. I found that very interesting to be reminded. English common law, let me repeat, it perceived committing suicide as an immoral and criminal offense against God and also against the crown. However, a change did come through Suicide Act 1961. There was an amendment here again to Homicide Act 1957 for England and Wales. For Suicide Act 1961, Section 1 said suicide now was to cease to be a crime. I read, the rule of law whereby it is a crime for a person to commit suicide is hereby abrogated. However, Suicide Act 1961, where criminal liability for complicity in another suicide was not removed. It remained intact. As a matter of fact, there was a penalty for imprisonment for 14 years, as it were. So what is important to notice for this is that suicide in itself was normal criminal offense, but to assist someone to commit suicide or to die remained as it were. Now, what is before us, members of the House of Lords, is something almost taking us to consider not only is committing suicide lawful, but in some instances, to assist someone to die, / to commit suicide at their request, should now be permissible. However, I would like kindly peers and the Lords that you be minded in the case law of Dy1ng versus Director of Public Prosecutions in 2001, to which the House of Lords gave a judgment, which in my view cannot just be easily dismissed. I'm very grateful, having located, you'll see, the Center for Adult Social Care Advice, Information, Dispute Resolution, followed that case, and I will share with you verbatim, so that I don't lose its importance. Articles 2, the right to life. Article 3, freedom from inhumane and degrading treatment. Article 8, the right to respect for home, family, and private life. Article 9, freedom of thought, belief, and religion. Article 14, freedom from discrimination in the context of one's inhuman rights. You will see from the convention how the House of Lords then gave its interpretation to a similar case before them. Now, Mrs. Pretty, who suffered terminally ill from motor neuron disease, appealed against the dismissal of her application for judicial review of the Director of Public Prosecution's refusal to give an undertaking not to prosecute her husband under Section 2, 1 of the Suicide Act 1961, to which I referred to earlier on. This were he to assist in her suicide. Just in a nutshell, Mrs. Pretty was trying to appeal that Section 2, 1 of the Suicide Act would not be activated if the husband assisted to have her commit suicide to her request. I continue. Mrs. Pretty claimed that the DPP's refusal then was a breach of Articles 2, 3, 8, 9, and 14 of the European Convention, right to life, freedom from inhuman and degrading treatment, right to respect for private life, freedom of conscience, and freedom from discrimination, respectively. But my Lord, see how this developed. Upholding that dismissal by the House of Lords, the House of Lords held as their argument that the DPP did not have power to decide not to prosecute where the offense had yet to be committed, and that Section 2.1 Suicide Act 1961, very important to note, was compatible, not incompatible, was compatible with the convention. The right to human dignity enshrined in Article 3, please note, peers, was a right to live with dignity, not to die with dignity. I underlined that purposely. That was the interpretation, as I seem to follow, by the House of Lords. Then, Article 3 was a right to live with dignity, not to die with dignity. And taking active steps then to bring life to a premature end was very different from taking a futile and undignified steps to prolong life beyond its natural end, the House of Lords argued. While some convention rights had been interpreted as conferring rights which were the antithesis of that which there was an express right to do, example, the right to freedom of association in Article 11, confers a right not to join an association, or Article 2 could not be interpreted in that way so as to give a right to die. I repeat, as so not to give a right to die. Then in its argument and then conclusion, the House of Lords came up with this. The protection of human life was a legitimate social aim which justified interference, really, yeah, with the rights to respect for private life. I find that very interesting. And freedom of thought and conscience under Articles 8 and 9. Further, Article 8 was expressed in terms directed to the protection of personal autonomy while individuals were living their lives, and there was nothing to suggest that it had any reference to the choice to live no longer. Mrs. Pretty's contention that she had suffered discrimination in the enjoyment of her convention rights because of her physical incapacity could not be sustained, as Article 14 was not free from standing and was only applicable in cases where other convention rights were in play. In any event, the House of Lords concluded, in any event, the Suicide Act 1961 did not give a right to commit suicide. It merely abrogated the rule of law whereby it was a crime for a person to commit suicide. Let me repeat. The Suicide Act did not give a right to commit suicide. It merely abrogated the rule of law whereby it was a crime for a person to commit suicide. Therefore, Mrs. Pretty's appeal to the Human Court of Human Rights was unsuccessful. I'm bringing this because a line of legislative and legal reasoning can still follow today the similar pathway. Obviously, we have now the UK Human Rights Act 1998, but we are still signatories to the European Convention of Human Rights. That is, UK is still a signatory. It is important at this juncture for me to point out that on the 30th of July, 2009, the judicial function of the House of Lords and its role as the final and highest appeal court in the UK ceased. It stopped. And a new Supreme Court albeit separating the judicial function from Parliament. It opened on the 1st of October 2009, being placed opposite the House of Parliament in the Parliament Square. I'm bringing this that albeit one can argue that the function of the House of Lords ceased. But I want you to see how a similar argument was followed through to this new body of the Supreme Court. For in 2013, 2014, 3 cases of individuals with terminal illness came to be considered in the Supreme Court before the 9 Lord judges. At this juncture, it was Lord Nuremberger as president. I'm bringing this for you to see and be reminded of how this Supreme Court, having just taken over from the House of Lords, followed as more or less a similar case. Now, the 3 cases argued they wanted there to be assisted to die. They wanted assistance to die. And they used Human Rights Act 1998, Article 2, that they had a right to life. And the second argument from Human Rights Act 1998 was that they argued for their right to respect privacy and family life. But then the Supreme Court brought Suicide Act 1961 here again into play, that indeed an individual may decide to commit suicide, but no other party was acceptable to assist in that committing suicide, in this case, assisting someone to die. That is where we are at now. This is crucial because if this law is passed to assist to die, that is, one can not only, if able, commit suicide, but if not able to commit suicide, invite someone to assist them to commit suicide or to die. How did the Supreme Court, under those judges, deal with this? I found it interesting that the judgment given on the 25th of June 2014, and by the way, this case had been heard from the 16th to the 19th of December 2013, Lord Nuremberger, the president, you'll see this slide before you, section 116. This was the argument given. And I read it as it is. There is a number of reasons which, when taken together, persuade me that it would be institutionally inappropriate, mark that, at this juncture, for a court to declare that Section 2 is incompatible with Article 8 as opposed to giving Parliament the opportunity to consider the position without a declaration. Goes on. First, the question whether the provisions of Section 2, this is crucial to me, of the Suicide Act 1961, the question whether the provisions of Section 2 should be modified, rather changed, raises a difficult, controversial, and sensitive issue with moral and religious dimensions, which undoubtedly justifies a relatively cautious approach from the courts. You may say, well, after all, this is a court. We're dealing with a legislative issue going through Parliament. But its essence to me remains the same. It is a cautious approach that is being given here. This was followed by Lord Nuremberger in the same section of 116, if you follow me, referring now to Pretty versus Director of Public Prosecutions that we dealt with earlier in the House of Lords. Albeit this is the Supreme Court, but he brings it back. See his conclusion. Less than 13 years ago, the House of Lords in Pretty versus DPP gave Parliament to understand that a declaration of incompatibility in relation to Section 2 would be inappropriate. The Supreme Court is making a reference to the then House of Lords. Let me repeat for emphasis' sake. Less than 13 years ago, the House of Lords in Pretty versus DPP gave Parliament to understand that a declaration of incompatibility in relation to Section 2 of 1961 Suicide Act would be inappropriate. A view reinforced by the conclusions reached by the Divisional Court and the Court of Appeal. In this case, a declaration of incompatibility on this appeal, according to Lord Nuremberger, would represent an inherent volte-face. This seemed to be echoed by Lord Reed in the same judgment. The question whether Section 2 of the Suicide Act 1961 is incompatible with the Convention's turn on whether the interference with Article 8 rights is justified on the grounds which have been discussed. That issue, according to Lord Reed, raises highly controversial questions of social policy and, in the view of many, moral and religious questions on which there is no consensus. I'm just bringing these peers for reflection as you go through whatever amendments of what is before you. I know there are some voices already out there, almost giving the impression that the peers are just appointed individuals. It's an appointed body. It's only the members of Parliament that carry weight for they are closer to the electorate, to the people. But you have a duty, away even from such rhetoric, on this private members' bill before you, terminally ill adults, end of life, to really make a decision. Is it legal? Is it lawful? It was illegal then. In the same house you find yourselves. Those who followed the House of Lords, the Supreme Court, were in no doubt not ready to give a green light. I would just want to end on this note that, as I believe, you will not be any under pressure, for your responsibility will be historic when this piece of legislation is carried out. I'm thankful once again for you taking time to listen to this presentation, and I will be available, even if invited by your committee during the committee stages, for me to amplify or add to issues that I find already have not been provided a clear legal or legislative pathway, to which I believe you will be grappling with. So I'm available. But for now, I'm so grateful for the time you have made just to listen to this. But as I said earlier, not only you, but anyone who will have accessed this presentation. Thank you so very much. I appreciate you just listening to it.